Hi everyone, this is Ed, not AI, with another Ed Talk about the Donna Adelson case. Here is the latest. Judge Everett denied Donna's motion to suppress the jail call, where she was recorded talking to other people in her home after she thought the call got disconnected. Judge Everett's order is brilliant, and we will read it to you shortly. First, let me share another important piece of information about the case. Donna Adelson's attorneys filed a notice that they will take the deposition of Sigfredo Garcia at the Franklin Correctional Institution on March 10th. Surprisingly, the certificate of service does not list Sigfredo Garcia's new lawyer, Mike Mann of Pensacola. You see, Mike Mann, a young lawyer who graduated from a Mississippi law school in 2018 and was admitted to the Florida bar in 2019, and runs what appears to be a personal injury trial law firm, filed an appearance in Sigfredo's case on February 19th, 2025. Remember that Sigfredo Garcia never spoke to authorities after being charged and did not testify in his trial. He still, apparently, maintains his innocence and is seeking a new trial through his post-conviction motions, claiming that his trial counsels were ineffective. We're not sure what Donna's lawyers are expecting to get out of the deposition. We presume that his lawyer will simply tell him to plead the fifth and to only talk if he ever decides to cooperate in exchange for a reduced sentence. Why would Donna want to depose him? If Donna had no direct contact with either Sigfredo or Katie, as we all expect, then she can try to get Sigfredo to confirm that. However, we strongly doubt that he'll say anything. We look forward to seeing what happens. All right. Let me read to you, skipping some of the citations, Judge Everett's excellent order. Here we go. Order denying defendant's motion to suppress. This cause comes before the court on defendant's motion to suppress, filed with the clerk on February 10, 2025. The court, having considered the motion, the evidence admitted during the February 26, 2025 hearing, the arguments of the parties, defendant's supplemental memorandum of law, the court file, and being otherwise fully advised in the premises, finds and adjudges as follows. Background. On November 7, 2023, defendant received a phone call from the Leon County Jail to her cellular phone while she was at home in her apartment. The caller was her son, Charles Adelson. At the time, Charles Adelson was an inmate of the Leon County Jail, incarcerated there since his arrest on April 21, 2022. One day prior to the phone call at issue, Charles Adelson was convicted of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Before being permitted to speak with her son, defendant was required to acknowledge the following message and consent to its terms. The message disclosed. Hello, this is a prepaid collect call from Charlie, an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. To repeat, thank you for using Securus. You may start the conversation now. See Defense Exhibit 2 and State Exhibit 4. This preamble is the standard notification advising individuals who receive phone calls from the Leon County Jail that the calls will be recorded. Thus, to speak with a Leon County Jail inmate through this phone system, the non-inmate must give consent to being recorded unless it is a private call. Defendant concedes she was informed of this notification when she consented to speak with her son on this recorded line. Approximately 8 minutes into the phone call, Charles Adelson was disconnected, leaving only defendant's phone still being recorded by the Securus phone system. At that point, defendant said, quote, "Can you hear me, Charlie? Shit. You can't hear me again, right? Charlie? Charlie? Can you hear me? I'm sorry. The fourth time that they cut the line each time." See Defendant's Exhibit 2 and State Exhibit 5. She then began a lengthy conversation with other people who were inside her home. These people were her husband, her attorney, and her estate planner, Susan Brotman, and Mrs. Brotman's husband, Richard Chagrin. Defendant testified that Mr. Chagrin is not an attorney. While the issue of privilege is not raised through this motion, a recognized privilege can be waived by voluntary disclosure or consent. Given that defendant was conversing with people other than her son, referring to her son as he and him while talking about him, and revealing facts she did not have the heart to tell him, her words, the court is convinced defendant subjectively believed their shared phone call had ended and any ensuing conversation private. See Defense Exhibit 2 and State Exhibit 4. Subsequently, over the next 15 minutes, defendant alluded to committing suicide, professed she was looking for countries that did not have extradition agreements with the United States, wondered whether Vietnam has an extradition agreement with the United States, and spoke about a conversation she had with her daughter, Wendy Adelson, about giving her, quote, papers and wills, unquote. See Defense Exhibit 2 and State Exhibit 5. Eventually, someone other than defendant realized that the phone call had yet to end and ended the call. It was only at this point that the phone call terminated and the recording stopped. Investigator Jason Newland testified this is standard protocol for phone calls originating from the Leon County Jail. Defendant argues it was an unlawful, warrantless interception to record her conversation after Charles Adelson was disconnected because she believed the phone call and recording had ended. Analysis. Before a trial court will consider, quote, the merits of a Fourth Amendment motion to suppress, the defendant must first establish a factual basis justifying his or her claim to have possessed a Fourth Amendment right at the time of the alleged invasion, unquote. Nemensky v. State. Regarding oral communications, quote, for an oral conversation to be protected under Section 934.03, the speaker must have an actual subjective expectation of privacy, along with a societal recognition that the expectation is reasonable. State v. Smith. Accordingly, quote, to successfully claim the protection afforded by the Fourth Amendment, a defendant must demonstrate that he or she personally has an expectation of privacy and that this expectation is reasonable. State v. Washington. Defendant argued in her written motion that the state bears the burden of justifying its alleged warrantless interception and moved to suppress the oral communications she uttered after Charles Adelson was disconnected from the phone call. However, the written motion misstated the burden of proof because, quote, a Fourth Amendment search does not occur even when the explicitly protected location of a house is concerned, unless the individual manifested a subjective expectation of privacy in the object of the challenge search, and society is willing to recognize that expectation as reasonable. Kylo v. U.S. As a result, it is the defendant who must first establish a search occurred within the meaning of the Fourth Amendment. See Washington. See Hicks v. State, citing Rackus v. Illinois. Therefore, to support suppression of a communication order under the wiretap law, the person who made the statement must show more than a subjective expectation of privacy. They must show that they have a reasonable expectation of privacy under the circumstances, which depends on one's actual subjective expectation of privacy, as well as whether society is prepared to recognize that expectation as reasonable. Smiley. Because the court concluded defendant did subjectively expect that her conversation was private, this motion turns on whether society is prepared or willing to recognize such subjective expectation as reasonable. See Kylo. After conducting a thorough analysis, the court has determined defendant's conversation did not constitute the unlawful interception of an oral communication under Section 934.06 Florida statutes. Reasonable security measures of Leon County Jail. To ascertain whether society is prepared or willing to recognize defendants' subjective expectation of privacy as reasonable, the court begins with the well-established principle that citizens are guaranteed a reasonable expectation of privacy in their own home. State v. Mozo. The court also recognizes that jails and correctional facilities have a strong interest in preserving and maintaining their security, and, quote, the interception of calls from inmates to non-inmates does not violate the privacy rights of the non-inmates, U.S. v. Willoughby. See also Jackson v. State. 1. Jackson did not have a legitimate, reasonable expectation of privacy in a recorded phone call that was placed while incarcerated after receiving warnings that the call was being recorded. And 2, the interest in institutional security allows jailhouse conversations to be monitored. In addition, it does not matter if the call is made to a non-inmate's home, see Willoughby. Nor do we find merit in Willoughby's contention that his own privacy rights were entitled to greater protection than those of Quinton because he received Quinton's call in his home. Thus, defendant relinquished her reasonable expectation of privacy when she answered her phone and consented to speak with her son. Defendant argues that she regained a reasonable expectation of privacy previously relinquished through consent once her son was disconnected, but she did not actually terminate the phone call from her end. During the hearing, the state contended that the primary basis for denying defendant's motion to suppress was that it did not intentionally record defendant's conversation. The state also argued defendant did not have a reasonable expectation of privacy, arguing that the reasonable expectation only begins once a person actually hangs up the phone. The court disagrees. The Leon County Jail intentionally utilizes technology developed by the company Securus that, by design, continues to record conversations between inmates and call recipients until both parties disconnect. If the decision to record prior to the inmate's disconnect is intentional, as the state's argument concedes, it stands to reason the decision to record after the inmate is disconnected is also intentional. See Hence v. State. However, in determining whether an expectation of privacy is reasonable, quote, courts should examine the location of the conversation, the type of communication at issue, and the manner in which the communication was made. See State v. Caraballo. Although the location of defendant's conversation occurred within her home after her son was disconnected, the fact remains she consented to receiving a phone call from a jail facility. The type and manner of the communication are also quite different from ordinary phone calls. This phone call, 1, began with a message stating it was not private, 2, required acknowledgement that it is being recorded, 3, required consent to proceed, and 4, utilized third-party technology to facilitate recordings between inmates and non-inmates. Even if many modern cellular phone devices typically terminate a phone call when one party is disconnected, as defendant stresses, communications from jails and correctional facilities have unique institutional safety concerns that are not at issue in common communications between non-inmates. Thus, defendant's subjective expectation was built on a false assumption that dropped calls involving the Leon County Jail have the same result as dropped calls involving at least one cellular phone. Footnote: on this point, defendant's hearing testimony was inconsistent when she acknowledged a belief that calls from the Leon County Jail end whenever an inmate is disconnected, while also admitting she hung up her phone each time. Charles Adelson was previously disconnected before November 7, 2023. Whether defendant forgot to hang up her phone or assumed it was unnecessary, society would be unwilling to recognize her expectation of privacy was reasonable under either circumstance. This assumption is unreasonable given the concerns correctional institutions and jails encounter. See United States v. Sababu. See also Willoughby. For example, a federal court of appeals has remarked that the Bureau of Prisons, quote, recording system and the random live monitoring of telephone conversations have assisted in the detection of escape plans, of schemes to smuggle controlled substances into the facility, and of inmate identification of another inmate as an informant in the government's witness protection program. Willoughby. There is no plausible reason why the Leon County Jail should not be afforded deference in how it uses a recording system to safeguard against similar security concerns, including by continuing to record an inmate's phone call until both parties have disconnected the phone. See Bell v. Wolfish. Quoting from it, prison officials must be free to take appropriate action to ensure the safety of inmates and correction personnel, and to prevent escape or unauthorized entry. Accordingly, we have held that even when an institutional restriction infringes a specific constitutional guarantee, the practice must be evaluated in the light of the central objective of prison administration, safeguarding institutional security, end quote. Security risks do not dissipate when only the inmate disconnects the phone call. In the ever-evolving technological world, inmates and non-inmates can exploit loopholes to circumvent institutional safeguards. See Prison Legal News v. Secretary, Florida Department of Corrections. Quoting from it, some inmates evade or break the rules restricting their privileges. For example, the department's telephone security vendor can detect three-way call attempts by the clicking noise that occurs when a call is transferred, but inmates will blow into the receiver when transferring a call to mask the clicking noise, unquote. And, as the federal courts have opined, quoting, it is difficult to imagine that the considerations that justify monitoring and recording of a prisoner's utterances could somehow not apply at the other end of the telephone. The rights of free persons may well at times be implicated and stand or fall with the rights of prisoners. See Sababu. Defendant's subjective expectation conflicts with her own knowledge. Charles Adelson was arrested on April 21, 2022. The portion of the conversation defendant seeks to suppress occurred on November 7, 2023. That period spans a difference of 565 days. Based on the sheer volume of calls between defendant and Charles Adelson, she cannot reasonably claim to have been unfamiliar with how the Leon County Jail facilitates phone calls from inmates. This asserted subjective expectation became less and less reasonable with each time she answered a phone call from the Leon County Jail, consenting to recorded calls until both parties are disconnected. She cannot even claim to be unfamiliar with what transpires when a Leon County inmate's phone is disconnected because she is heard acknowledging on the November 7th, 2023 recording that her son has been disconnected for the fourth time. Defendant testified her son was frequently disconnected during their phone calls he made from the Leon County Jail. During these other instances, defendant answered she would ordinarily hang up the phone after he was disconnected, suggesting she realized she needed to hang up her phone to end or terminate the calls. Thus, rather than expecting her phone would automatically disconnect, her own testimony reflects that she was aware that calls from the Leon County Jail would continue unless and until she hung up her phone. Expecting an opposite result or outcome from what has taken place previously and repeatedly is an expectation society is unwilling and unprepared to recognize as reasonable. See Huff v. Spa. Quoting from it, a person who knowingly operates a device that is capable of inadvertently exposing his conversations to third-party listeners and fails to take simple precautions to prevent such exposure does not have a reasonable expectation of privacy with respect to statements that are exposed to an outsider by the inadvertent operation of that device. See also United States v. Mongoor. Quoting from it, any expectation of privacy in outbound calls from prison is not objectionably reasonable, and the Fourth Amendment is therefore not triggered by the routine taping of such calls. Conclusion. For these reasons, the court cannot conclude society is prepared to recognize as reasonable defendant's subjective expectation of privacy in the November 7, 2023 phone call. 1. The phone call was received from a jail or correctional facility with a valid interest in preserving security by continuing to record phone calls until both parties of the call have disconnected their phones. 2. Defendant's subjective expectation was contrary to her own familiarity with the Leon County jail phone technology and prior user-based knowledge. And 3, expecting different outcomes or opposite results from what has repeatedly occurred is intrinsically unreasonable. It is ordered and adjudged that defendant's motion to suppress is hereby denied, done, and ordered in Leon County, Florida, on Monday, March 3rd, 2025. Signed, Stephen Everett, Circuit Judge.
Thanks for watching and supporting us. It is thanks to your continued support that we keep bringing you exclusive cases like this one. Keep in mind that we have expanded our channel to include many types of content, from talk shows and interview shows to deep dives in the files of criminal cases. Until next time, this is Tracy and I'm signing off from Atlanta. Deep Dive True Crime, Mentor Lawyer Justice Network.